Welcome to The Explainer. I am honestly so thrilled to have you here today. Okay, so we're going to explore a topic that is literally the backbone of global business, yet it mostly operates behind closed doors. We're looking at international commercial arbitration, specifically through the lens of Republic Act 9285 and the UNCITRL model law. If you've ever wondered how these massive cross-border corporate disputes actually get resolved without descending into total chaos, well, you're in exactly the right place. Think about it. When a multi-million-dollar international deal goes sour, who actually decides the winner, right? Do you just flip a coin? Do you drag a foreign company into your local courts? Or worse, do they drag you into theirs? The stakes in these global deals are astronomical. And global businesses, they simply cannot afford to rely on unpredictable or unfamiliar foreign courts. They need a totally different toolkit. And that toolkit is exactly what we're unpacking today. So here's our roadmap. We'll be covering 1. Defining commercial arbitration. 2. Forming the arbitral tribunal. 3. The tribunal's powers. 4. Conducting the proceedings. 5. The final award. And 6. Setting aside the award. We're basically going to track the exact chronological life cycle of a dispute, literally from birth to resolution. Section 1. Defining commercial arbitration, the alternative to court. Okay, let's just dive right into this and establish our foundational terms so we're all on the same playing field. Now, the scope of commercial arbitration is incredibly broad. The rules specifically define it as covering matters arising from all relationships of a commercial nature, and get this, whether there's a formal contract in place or not. We're talking trade transactions, massive construction works, financing, banking, licensing, joint ventures, the whole shebang. Essentially, if it involves major business cooperation, it falls right under this umbrella. It covers nearly every major business relationship you could possibly think of. And this right here brilliantly illustrates why businesses actually choose this route. A traditional state court, it has rigid rules, judges assigned to you by the state, and it's a highly public venue. But an arbitral tribunal operates on the core principle of party autonomy. It's totally different. The state's policy actually actively promotes this freedom. You get a custom-built panel of decision-makers, and it's an entirely private process. It's flexible. It empowers the parties to make their very own arrangements to resolve their dispute. Moving right along to Section 2, forming the arbitral tribunal, building your court. I mean, if you aren't going to a traditional court, you kind of have to build your own, right? Let's look at how parties custom build their judicial body from scratch. 3. This is such a crucial default built into the rules. Now, the parties are totally free to determine the number of arbitrators they want. It's completely up to them. But if they fail to agree on a panel size, the law steps in and says, okay, the default number of arbitrators shall be 3. It's basically a built-in safety net just to keep things moving along. So how do we actually find these 3 people? Well, the rules provide a very clear step-by-step fail-safe mechanism. Step 1, each party appoints 1 arbitrator. Easy enough. Step 2, those 2 chosen arbitrators then get together and appoint the 3rd. But what if they deadlock? What if they can't agree? Well, that's step 3. If they fail to agree on that 3rd arbitrator within 30 days of being asked, an appointing authority steps in to make the final choice upon request. So you're never just left without a judge. The system always has a way forward. Now, what is really fascinating here is how incredibly strict the deadlines are to prevent delay tactics. Let's say an arbitrator is appointed, right? But then you discover circumstances that give rise to justifiable doubts about their impartiality. Maybe, I don't know, a hidden conflict of interest. From the exact day you become aware of it, you have exactly 15 days to send a written challenge to the tribunal. If the challenged arbitrator doesn't step down and your challenge gets rejected, you only have 30 days to ask the appointing authority to make a final, completely unappealable decision. So yeah, the clock is absolutely always ticking. All right, Section 3, the tribunal's powers. What can they actually do? So you've built your tribunal. You've got your 3 arbitrators ready to go. Now, what rules are they playing by? And what power do they actually wield? This is a super fascinating legal concept. The arbitral tribunal has the unique competence to rule on its own jurisdiction. Think about that for a second. This means they get to decide if they even have the right to hear the case in the first place. Furthermore, an arbitration clause is treated as an agreement that is completely independent of the other terms of the contract. So even if the tribunal decides the main contract itself is, say, completely null and void, that doesn't instantly invalidate the arbitration clause. Their power to decide literally survives the death of the contract. And they definitely aren't toothless while the main case is pending either. The tribunal can order interim measures. While the fight is actively ongoing, they can order a party to take action to prevent irreparable loss or injury, provide security for an obligation, or preserve critical evidence that might otherwise just disappear. They can essentially freeze the board so nobody can cheat while the game is being played. Which brings us to Section 4, conducting the proceedings. The battle begins. We have our tribunal, and we know their powers. Now we move into the action phase. How do the actual proceedings take place? I really want to continually hammer home the core theme of this entire system: party autonomy. Who decides the place of arbitration? The parties. Who decides the language to be used in all written statements and hearings? The parties. Who determines the rules of procedure? Again, the parties. You and your business partner completely dictate the language, the location, and the rules of engagement. You are completely in the driver's seat here. But, of course, the law has a backup plan if you forget to agree on something. Here's a surprising fact for you. Under these rules, if you draft a massive international contract and completely forget to specify the place of arbitration, your default venue is Metro Manila. Literally, unless the arbitral tribunal decides another place is more appropriate given the circumstances, failing any agreement, you are heading to the Philippines. Section 5, the final award, the decision. Okay, so after all the evidence is presented, all the experts have testified, and all the arguments are made, we finally arrived at the conclusion of the active fight. It is time for the final decision. Now, an arbitral award isn't just, a casual email saying who won. There are strict formal requirements necessary for it to be legally valid and enforceable. The award absolutely must be in writing. In a panel of 3, it must be signed by at least the majority of the members. It must state the reasons upon which it is based, unless the parties specifically agree they didn't want reasons, and it must clearly state the date and the exact place of arbitration. Straight from the text of the law, we see exactly how the process ends. The arbitral proceedings are officially terminated by this final award. Alternatively, the tribunal will issue an order for termination if the claimant simply decides to withdraw their claim or if the parties mutually agree to just end the proceedings. Once that termination happens, the tribunal's mandate is officially finished. Section 6. Setting aside the award. The afterlife. But wait, what if you lose? What if you truly believe the process was entirely unfair? Well, this brings us to the final stage of our life cycle, the afterlife of the dispute. What happens if the losing party tries to strike down the award in a regional trial court? So the absolutely crucial point is this. You cannot appeal to a court just because you lost or because you think the arbitrators misunderstood the facts. No way. The grounds to vacate an award are strictly, and I mean severely, limited to foundational flaws. A court will only set aside an award if there's solid proof it was procured by corruption or fraud, if there was evident partiality among the arbitrators, if the tribunal was guilty of severe misconduct, or if the subject matter simply cannot legally be arbitrated or conflicts with the public policy of the Philippines. It is a very, very high bar to clear. And if you are going to try to set it aside, you cannot drag your feet. 3 months. An application to set aside an award absolutely cannot be made after 3 months have elapsed from the date the party received the award. Once that 3-month window closes, that's it. The award is locked in. The whole system prioritizes finality so businesses can just move on. Which brings us to our final thought for today. If your global business faced a major crisis tomorrow, would you leave your fate to a completely unpredictable foreign court, or would you build your own tribunal? By understanding the life cycle of international commercial arbitration, from drafting the clause all the way to enforcing the final award, you are empowering yourself with the ultimate tool of party autonomy. You don't have to be a victim of circumstance here. You can engineer your own path to resolution. Thank you so much for joining me on this explainer, and I highly, highly encourage you to keep exploring how these powerful frameworks shape the entire global economy.